Hello and a very warm welcome to Ask the Property Experts. I'm Kura Chiota. South Africa's Consumer Protection Act came into effect in April last year and regulates the way businesses market their products and services, making South African consumers some of the most protected in the world. Joining me in studio to discuss what this has meant for the property industry is Herschel Jawitz from Jawitz Properties and Robbie Quello, a partner at Weber Wensels. Welcome to you both.
Thanks, Kira.
Now, Robbie, the CPA isn't a property-specific piece of legislation. What was the framing intention when this CPA Act, what was it put out there to address in our society?
Well, it was intended to address a number of evils, and may I mention, a lot of people have said that many of the provisions in the CPA aren't appropriate for the property industry. But essentially, it was introduced because of the perception that consumers were getting a hard deal, they had no redress, suppliers could dictate terms and conditions, and the like. So the intention was really to rebalance things and essentially make the consumer really king.
Now, this has made your life so much easier, hasn't it, Herschel? You didn't have to rewrite your offers to purchase, your leases and all of that. Well, that was some significant work from the property industry to actually get CPA compliant. How have you found it?
Well, I think the first thing was, like all legislation, the intentions are probably good, but how it was defined and as has been discussed, the impact on our industry has been quite significant, probably different from what was intended. So, the first step that the industry had to take, and most state agencies, was, what view are you taking on the Consumer Protection Act, and what are you going to do to your legal documentation and from a training point of view, because the potential consequences in terms of where the onus now lies in terms of protecting the consumer shifts to some degree from the seller's obligations for disclosure to the estate agent. So, I think most estate agencies have taken a view, let's comply with the Consumer Protection Act, let's amend our documentation, but it still has caused complications and it's still ongoing, and there are very few test cases as to how this actual Protection Act is going to work. So we're operating with documentation, but to some degree it's still a little vague.
Right. Now, tell me some of the aspects that are pertinent out of the CPA to specifically the property industry. We know that in particular instances, their properties under a certain threshold, 250,000, they already had a so-called cooling off clause. But now the CPA deals with things as temporary as cell phones, and the same act you're dealing with things as permanent as homes. A cell phone can break in 3 years and you say, well, that's out of warranty, but a home is supposed to have a 20, 30, 40-year life. What are you seeing as the property-specific elements that we need to take heed of in the CPA?
I think what's important, firstly, is to appreciate what the Act applies to and what kind of transactions the Act applies to, because it doesn't apply to all transactions in the property industry. So in essence, or in principle, the Act applies to all goods and services which are sold or supplied by a supplier in the ordinary course of business. So, for instance, many people don't realize that a person selling their property in their private capacity, as happens every Sunday, that transaction is probably outside the scope of the Act. So typically what we're concerned with is a situation where the seller or the lessor is acting in the ordinary course of business. So that's important to realize. The other thing that's important to appreciate is the fact that it doesn't apply to consumers that fall outside the threshold, and the threshold is 2 million rand. So in other words, that it only applies to consumers which have both an asset value and annual turnover of less than 2 million rand. That's if you're dealing with juristic persons. Otherwise, it applies to all individuals. So if you're selling a property to a company or CC that's above the threshold, the Act won't apply in most respects. The Act itself will regulate all aspects of marketing the property, selling the property, letting the property, to the extent the transaction falls within the Act. Everything from the way it is marketed, what is done or not done, what representations are made, that it's crime-free, close to schools, all of those sorts of things, the terms of the agreement, what happens after the agreement, how you enforce agreement. And that's why, as Herschel says, the role of an estate agent is critical. And in fact, many people, when things go wrong, will point fingers at the estate agent.
Yeah. Let's go to the word agent. All right. You have a principal and the principal is the owner of the property or the estate or the company, whatever it is, and they appoint you as their representative to handle a transaction on your behalf. Where does the responsibility lie in terms of defects and service when the front door, I put in the key and the door falls off, silly example, but do I come to the agent or do I come to the seller who sold me the defective property?
So, just in terms of the CPA, exactly what was mentioned, that 99% of sellers, unless you're a developer, you're not selling your house in the ordinary course of your business. You're a banker or a doctor or whatever it might be. So the onus in terms of the Consumer Protection Act and the protection that it should afford the purchaser then shifts to the agent being the estate agent, acting or providing a service to the seller. So that's the first level. The second part is that to some degree purchasers have been protected up until now in terms of various disclosures that sellers have to make in terms of when they're selling their home, as for example, what's working in good condition at time of transfer. Purchasers have always been protected with regard to latent defects, so that if they can prove, for example, that a seller knew about a defect and a material defect in a home and knowingly didn't disclose it either to the agent or to the purchaser, they can't escape it under the guises now of the Consumer Protection Act. But essentially now the burden of responsibility of asking the right questions, which we should be doing anyway as estate agents, is now far more formalized. So issues like size of property, you can't just represent to a purchaser that the seller thinks the home is 700 square meters under roof, when in actual fact the purchaser may be buying 500 square meters under roof. Issues like, are the buildings impacted by, are they historical buildings, are there any servitudes, all of the usual issues like plans being passed.
So everybody's getting more careful in what they put out there in the market.
Absolutely, and really the practical application is that estate agents now have to more formally ask the right questions of the seller, which they should have been doing anyway.
I'm going to have to take a break right now. When we come back, we're going to talk about that magical word, voetstoots. See you short just now. Welcome back to Ask the Property Experts. I'm Kura Chiota. Joining me in studio to discuss the CPA are Robbie Quello, partner at Weber Wenzels, and Herschel Jawitz of Jawitz Properties. Thanks for joining me again, gentlemen. The issue around voetstoots, you see it as it stands. The sellers and their representative agents have used that for time almost immemorial to say, look, we describe this thing, you could see it, touch it, taste it on the day, and I can't take any further responsibility. The CPA is like piercing that veil and saying, ho, 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 not so easy, Booty. You've got to understand what's there, and the shift of the burden of proof is somewhat different. How do you see the voetstoots now in the CPA world?
Yeah, once again, you need to distinguish between those transactions that are subject to CPA and those that aren't.
Okay.
So many people think voetstoots is dead. It's not dead. It's very much alive and well. So
I hear the agents applauding you right now.
But as Herschel said, there are always the qualifications. You can't just say something's voetstoots and get away with anything. There's still issues whether you knew of latent defects and things like that. But in the case of where the CPA does apply, in other words, where the sellers act in the ordinary course of business, whether that's selling the property or letting the property, then voetstoots doesn't apply. And there's certain implied warranties that the Act imposes by law, which you can't contract out of. There is an exception to that. As always with lawyers, there are exceptions, and one of the exceptions is if the purchaser or the lessee has been made aware of the particular problems. And it's not just a case of saying, oh, it's an old house. You would have to itemize these are the issues, and provided the consumer or the purchaser or lessee accepts those issues or acts in a way consistent with accepting them, then they can't then turn around and say, oh, but there's this problem or that problem. Some agents that I've dealt with have taken the view, well, what they're going to do is they're going to sit back and they're going to think of everything that ever goes wrong with the property. They're going to list it in a sheet and ask the consumer to sign. That's not going to be good enough. It's going to have to be an informed and specific list of issues which are disclosed to the consumer at the time as required by the Act.
Okay. Now, what are the practical issues that you've come across in your practice? You run several offices across the country. What are people coming at when they say, I'm taking this up in terms of the CPA? What are the complaints you're seeing on the shop floor, so to speak?
Thankfully, and just talking specifically about what we've done, we've drafted additional documentation which we ask our sellers to sign off on, which says that to the best of their knowledge, for example, they're not aware of plumbing issues or servitude issues or encroachments on building lines. Plans have been passed. So a lot of the significant issues we talk to our sellers about, and we ask them to disclose to the best of their knowledge, are they aware? So we've tried to cover as many bases as possible, but we haven't really had any specific issues that purchasers have raised. And I think the issue is here is that purchasers can't sit back and say, well, because there's now the CPA Act, we have no obligation or no responsibility to do a proper inspection of a home. In fact, so far as to go that if they have concerns about a home, almost to have the home professionally inspected, so that if there are issues that may not be visible or to the untrained eye, that they're raised prior to the agreement being signed. So we haven't had specific issues, and it's largely untested. I think the other area that we haven't spoken about is just fixed term contracts. So the other part is just, in terms of our exclusive mandates, where now potentially sellers, if they're not happy with the agent, have an opportunity to extract themselves from an exclusive mandate, potentially at a fee. Lots of concerns initially how that may impact on what estate agents want to spend on the marketing of the home and our commitment. But the reality is this, that if you're working with a professional estate agency who are doing what they're supposed to do, there should be no reason why you would want to withdraw from the exclusive mandate. There should be no reason why there are hidden surprises when you're selling and buying a home. And it really sits down with making the right choice about the right agent who is CPA compliant.
Now, the issue of fixed-term contracts, it's one thing to sign a 24-month cell phone contract. It's another thing to sign a 5-year or 10-year lease that landlord has secured finance against and what have you. And then you say, well, in terms of CPA, here's my 20 business days notice. I'm out of here. Is it that simple?
Well, nothing's ever that simple, and that's been one of the most contentious issues as to whether the CPA applies to leases. My view is it does, although you ask 3 lawyers, you get 3 different views. But given that I think it does apply, it does work on that basis. Bear in mind that right to terminate won't apply where the lessee is a juristic person, so that right to terminate fixed-term contracts.
So companies, trusts, Section 21s can't do that. But an individual, if I rented a house through Jawitz and I got transferred somewhere else, I could give them 20 business days and say I'm out?
Yeah, that's right, essentially. And there are also limitations on the lessor's right in the case of a lease.
Sure.
To exit in certain cases.
You'll say, well, if it was a year lease and you're wanting to get out at 6 months, how do you find that legal ground in the middle to say, okay, you've given me notice, fair enough, but as a consequence, I'm going to suffer damages, I may have the property vacant, I was expecting or anticipating so much income. How do you mitigate that?
Well, all you can do is comply with what the Act says, and that says you can only claim a reasonable cancellation charge, which by its nature, once again, you ask 3 lawyers, you're going to get three answers about what is reasonable. But, for example, it was mentioned earlier, some of the challenges estate agents themselves have where they signed fixed-term mandates. But if you're a lessor, they also experience other problems, because you'll sign a lease, let's say for a year, with somebody, you'll pay the commission to the agent, typically on signature of that lease, and all of a sudden the tenant cancels on you. Kind of what rights do you have to get back? The commission is paid in advance. Do you claim that back as part of your reasonable cancellation fees and the like? And I think that's one of the areas where consumers are aware of their rights and are regularly cancelling lease agreements under Section 14, which is that fixed-term contract clause.
All right. In a minute or less, Herschel, look back at 2012 for me as an estate agent and look forward to 2013 for me. How are you feeling? How did you feel?
I felt cautiously optimistic for 2012, and I think it's turned out that way. I think the market has performed a little better than most anticipated. Prices have held slightly better volumes, and I think the biggest challenge that we're going to have in 2013 is stock. There seems to be more activity in the market, more buyers around, more inquiries. I think people have a strong sense, low interest rate environment, property prices offering good value. It's time to buy. It's now a matter of affordability.
2013, hip hip hooray. flat, single-digit, double-digit growth?
I think we're going to have single-digit growth, but I think we're coming off a strong base, and I think we're going to see a gradual improvement in the market along with the economy and most other sectors.
From the horse's mouth. That's all we have time for from both Robbie and Herschel. I thank them for being here. If you've got a question for our experts, you can send it through to askpropertyexperts@summit.co.za. Remember, in property, there's no such thing as a stupid question. Thanks for watching, and see you again next week.